Our first case this morning is State v. Jennings. Each part will have 15 minutes to present an argument. Of course, as you can see, Mr. Kudichief, there's no one here to rebut, so you just have your full 15 minutes unless you want to say 5 minutes to rebut with yourself, but we won't allow you to do that. The arguments are being recorded. When you come up, please stay behind the podium. Please introduce yourself. Please make sure you don't move around too much so the video can catch you, and speak loud enough so we can hear you. If you were to be referring to any child, victim, or minor, please refer to them by initials rather than their full name in this case. With that, we read your brief and ready to proceed whenever you are.
Judge Carr, Judge Stevenson, Judge Sutton, good morning. May it please the court, I am Richard Kudichief. I am court-appointed counsel for Nino Jennings. I felt it important to come here today because there are some issues that I think are significant. You may say or think, well, now come on, Richard, look, your guy, client pled guilty, sentence within the range. What are we here for? And the reason I'm here is that we need to look at how a sentencing court comes up with a conclusion to serve, to render a maximum sentence. When is it proper to max out? When is it proper? When should mitigation kick in? And so the question is a break given enough for a basis to give an enhanced sentence? A gift, as it is said below. So one of the primary issues here is, do we use a plea bargain that the court thinks is a gift without a record to support that to give a maximum sentence? Because what's the concept in sentencing? Minimum sanctions. In other words, the penalty should fit the crime. So here we have, Mr. Jennings was charged, but not a shooter. There's no question about that. He did not murder anyone. He pled to what he did, robbery. So again, looking at minimum sanctions, was it a plea agreement? I'm not really sure on that. Not really, maybe. Is it a break given? No, it is not. This is not a break given at all. Your Honors, when does the state dismiss a murder charge? Come on. There's 4 defendants. All sentences were sentenced together. There's no PSR. The PSI was waived in this case. So here we get 3 years as the mandatory for the gun, 11 to 16.5. He got 14 to 20 and a half years, a maximum sentence. This is a robbery case. And
well, somebody did die. Somebody was murdered during the course of the robbery.
That's so true, Your Honor, and I think that's significant to examine because this is not a complicity case. My client is not charged, no, he's not charged as a principal. We know that complicity can be from this indictment. However, the complicity is not bared by the factual basis, and that's why this is a robbery gone bad. 4 individuals, they all bear their responsibilities. That's what the prosecutor said. Now, the standard of review, abuse of discretion, well, let's take a look at State v. Brunson, because the state was, well, they were so confident in Brunson that they didn't show up today. But in their brief, when they argued Brunson, they left something out. Talking about 2953.08. Well, in Brunson, which was a successor to Jones, Brunson said, well, okay, 2953.08, but however, the appellate court is not prohibited from reviewing a sentence, quote, when the claim is that the sentence was improperly imposed based on impermissible considerations. That's in paragraph 69. So it's not just the issue of sentencing factors here, it's also common law. It's also what is appropriate relative to sentencing precepts. This is not a premeditated murder case. Nino did his robbery, then somebody else goes off the hook and shoots somebody.
So what are you saying what is your specific argument here that was impermissible for the court to consider? That there was a murder in this case that no one was convicted of, what did the court impermissibly consider?
No, I don't know what the court considered, other than it's in the transcript, by the way, but what the court did consider, and what the court consistently said was, this is a plea bargain gift. you got a gift, you got a break, so therefore, you know, they dismiss the murder, and so I'm gonna hit you hard on the robbery. That's not what it's all about. There's no evidence in the record whatsoever that there's insufficient factual basis in the record. Apparently, the judge hears evidence presented in another case, I think in a jury. I don't know what it is, because it's not clear in the record. But what this is, you take it on face value, it's a plan to rob that went bad, and they did that. I mean, my client did that. But let's look at this as well. Nino, my client has no prior record. He sat down with prosecutors and police, and he gave a proffer. He was cooperative. He agreed to testify, and he did so apparently consistently, not constantly, as I said in the brief. But at the proffer, he accepted responsibility. The state believed his testimony, said that he testified truthfully and consistently, and he got no consideration for this in the way, if you look at the totality of the circumstances. He shows remorse, he has insight, he acknowledged his family members. So, you know, what's the value in doing all that when you max out? Now, counsel for Nino stated clearly that Nino never imagined that someone was going to lose his life, and I can believe that. The maximum sentence, however, then is not appropriate. It's unfair because the punishment simply does not fit the crime. Now, the court said, well, you should have known somebody was going to die. No, that doesn't follow. And secondly, that's not what it is for individual examination and sentencing. So the court said he got his break in the plea bargain. He got a quote-unquote gift in the plea agreement. Although, really, Your Honors, you must take a look at that. Did my client get a gift in dropping that murder? No, absolutely not. What he did get is a murder sentence. So the abuse of discretion, or the nature of, if you look at Brunson, is the sentence is imposed improperly based on the impermissible considerations that the court made when it came to its sentencing considerations. Even the prosecutor said, look, this is an unusual case. You've got 4 defendants. Each should be judged individually for their actions. But the court didn't do that. The court did not judge individually the person of Nino Jennings. So look at the purpose of, felony sentencing. These are basic legal concepts, not just 29, 29, 11, or 12. Protect the people of the state of Ohio from future crime. Well, there's no record. He's not likely to reoccur. So again, the concepts in sentencing is use the minimum sanctions, as well as incapacitate Nino, deter him and others, and rehabilitate a person. So the reason for a court to render the maximum sentence on the theory that he received a gift is wrong, and that's exactly what this court should talk about and should rule upon. You can't utilize, plea bargains as a reason for maximum sentence. An effect should be given to the intention of the state and the defendant in the plea bargain. And the court should thus, if they accept the negotiation, enforce the terms of the agreement. That is a plea to robbery and not murder. Why? Because Nino didn't commit murder. And that makes sense. So without the PSR, there's nothing in the record to support that. Now, the court was not guided by overriding sentencing principles, either in 2911, 2911, or 12 or 13. And when you look at the underlying principles, it's not just here, it's conceptual, and it makes sense. What is the purpose of sentencing? Whether we're sitting here or down the street in the United States District Court, it's the same. We need to put in the minimum sanctions without unnecessarily punishing an individual. And so when we look at the record, it doesn't reflect that the court considered these purposes and principles, whether it's off of what the state recited or not. The record does not demonstrate in any way that the court adhered to principles, but more importantly, the court used improper considerations in rendering the sentence. So, using the dismissed murder charge as a basis for maximum sentence is simply wrong, not to mention the clear abuse. The clear evidence was he did not intend in any way to commit a murder. He didn't expect anybody to get killed. So I think Nino Jennings has clearly overcome any presumption that the court needs to consider safety factors relative to his behavior, his future potential recidivism, and I guess in conclusion, my thinking is this. This was a negotiated plea of sorts. The state dropped the murder charge. Did Nino Jennings get away with murder? Is that what happened here? Now listen, all of us know, we used to be lawyers. There ain't no prosecutor that's gonna dump a murder charge when they have evidence of a murder. And when you take a look at the exposure to murder, it's a life sentence jail. Why would the state dismiss a murder if it had evidence? Well, it wouldn't. And that's why it's so critical to examine the plea bargain and how we get to maximum sentencing. Because whether or not the state of Ohio feels that 295308 removes this case from any potential appellate review or change of sentence, which is totally wrong, even under Brunson. This is a case that needs to be scrutinized by minimum sanctions, common law principles of sentencing, and fairness and due process. How do you do everything that's right, accept responsibility? How do you proffer? How do you give remorse? How do you say to the family, I'm so sorry? How do you take a first-time offender and max him out for a robbery? And the reason that that was done is because the court improperly did look at impermissible considerations in the basis for a sentencing. So I ask this court to review that particular principle and say to a trial court, you can't just from yourself say you got a gift because the state dismissed a murder charge, because then maybe this court shouldn't be accepting a plea bargain, a negotiated plea, but rather say you're going to trial. But that's not what happened here, and that's why the court was wrong in rendering a maximum sentence.
Seeing no other questions, thank you for your presentation today, Mr. Kudichev. The court will take the matter under advisement and issue a decision in due course. As you know, the clerk will mail a copy of that decision to you once released, and will be available on the Ohio Supreme Court website.